Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. And in this video, I want to talk to you about what happens at a felony readiness conference, particularly in San Diego. A lot of times in different counties, they're called pre-trial conferences, they're called readiness conferences. Let's assume for purposes of this video, we're going to call all status, all pretrial conferences, all readiness conferences the same thing, a readiness conference. And what we're talking about specifically are felonies, and if we're dealing with downtown San Diego, located at 1100 Union on the corner of Union and C, the downtown courthouse, we're dealing primarily with departments 1101, 1102, and 1103. If we're dealing with Chula Vista, the South Bay courthouse, we're dealing with department 14. If we're talking about Vista, up in North County, we're dealing with departments 5 and department 6, depending on whether you're before a preliminary hearing or after a preliminary hearing. And in El Cajon in East County, we're dealing with departments 2 or departments 10. Departments 10 is sort of open during COVID as the readiness department, where historically department 2 was always your readiness department in felonies in East County. So what happens? A lot of times clients will come in and when they're interviewing our firm or we're meeting with them or speaking to them for the first time, they're, hey, what's going to happen? I have a readiness conference. I want to bring on your firm. What happens at that hearing? Well, a couple of things happen at a felony readiness conference hearing. Well, one is, what can happen is we will just confirm the previously set preliminary hearing. So you may have at your first court date, you enter your not guilty plea, they'll set 2 new court dates. Your readiness conference is November 15th. Your preliminary hearing is December 15th. So sometimes you go into November 15th and you and the district attorney are worlds apart. You may believe, whether justifiably or not, that your case should be dismissed. You may believe that your case is worth a certain thing and the district attorney may be worlds apart from it. And there are some cases that just need to be flushed out at a preliminary hearing, and there's some cases where you're factually innocent and you're not even going to consider to plead to anything, nor should you. So in that situation, one thing that can happen at a felony readiness conference is you confirm the future preliminary hearing date. So you're not changing any dates, you're just confirming the date that was previously set. Another time what happened at a felony readiness conference in San Diego is you could reset dates. So you may be waiting on some mitigation evidence, some evidence that'll help tell your story, give the prosecutor, give the court information about you before, during, and after this alleged offense, to really differentiate you from any and every other person alleged to have been committed those types of offenses. And that's really, really valuable. So your attorney may need more time. Prosecution may need some more time to consider what you're presenting or what your attorney is presenting. And in some instances, the prosecution may be a little bit behind in getting your attorney the discovery, the police reports. Maybe they're waiting on a surveillance video. And a lot of times what I see happen way too often, and it's a big mistake that a lot of defense attorneys make, is they'll start negotiating a case with the prosecutor when they don't have the discovery. When they may only have a couple of reports, but they don't have the surveillance video. They don't have the recordings of these interviews that's summarized in a police report, and the defense attorney is assuming and relying upon what's in the police report is true. Not doing their own research, not doing their own investigation, not doing their own work to put in the time to review the actual audio, to hear the context which those statements were made. So sometimes your attorney may need a continuance, or they should need a continuance before they start negotiating a case if that's in your best interest to try and negotiate a case at a readiness conference. And other times, if there is an agreement between the prosecution and the defense, or the defense and the court, sometimes at a felony readiness conference, oftentimes at a felony readiness conference, a case resolves by way of a guilty plea to something. Whether it's a lesser offense, whether it's what you're charged with for a benefit at sentencing, whatever the case may be, most cases resolve eventually, whether before or after a preliminary hearing, at a readiness conference. So those are the departments, those are the judges who, a lot of times your case may resolve. It doesn't mean necessarily that's when your sentencing would be. Usually sentencings are about a month out after you enter your guilty plea. But your sentencing would be in that readiness department. It would just in all likelihood be in the afternoon as opposed to the morning calendar. So a couple of things in summary. What happens at a readiness conference? District attorney, your attorney, judge, meet. They talk about the case. Where are we on this case? What do we need? Are we going to confirm the preliminary hearing? Does your attorney or the district attorney need more time? Is there a reason that a continuance is appropriate. Maybe the district attorney hasn't turned over all the discovery, and your defense attorney knows enough what they're doing not to negotiate the case without reviewing most, if not all, of the key discovery. Or is it just a situation where there's an agreement in place, you're going to resolve the case and then have your sentencing, 20 court days, which roughly works out to around a month or greater down the road. So those are the things that generally happen at a felony readiness conference. If you have any questions about your matter, you're not getting those questions answered by your current attorney, maybe time to make a change, feel free to reach out to my firm, 619-295-3555. Again, David Shapiro, where my firm helps good people regain control of their future when charged with a crime.